Assalamualaikum warahmatullahi wabarakatuh. Welcome back to the double ADR class. Good afternoon for you, those of you who watch this at noon, or good morning or good night. Before today's meeting, we're going to discuss about the mediation and conciliation, which was previously you have discussed, or we have discussed about the negotiation, and previously again we discussed about the double ADR. What is arbitration and what is ADR? Now we move to the mediation and conciliation. So for the as we're going to talk about the mediation and conciliation within the national regime or Indonesian law regime, so probably we will discuss some things about this law, which is I think in your PowerPoint would be a slight different because some of the law are the same, but then you can just refer to this law because this one is the correct one. So the first one is the law number 30 1999 on arbitration and alternative dispute resolutions. So this is the main law and the first basic law governing about arbitration and mediation as well as conciliation. Then there is Supreme Court Regulation number 1 2016 concerning mediation procedure in the court, as well as the law number 13. Okay, so the second one, the Supreme Court Regulation, is also the one most important rule in regards with the mediation, because this we're going to discuss that this law oblige the parties, the disputing parties, to have mediation before settling their dispute through the litigation process. And then the law number 13 2003 concerning manpower, which is also relates to the law number 2 2004 concerning the industrial relations dispute settlement. So yes, manpower, in regards with the manpower, the dispute settlement should follow the industrial relation dispute settlement first before going to the court. Even there is the special court for these industrial relations, which is Industrial Relations Court, which located or it established on the environment of the district court. And then OJK regulation or Financial Services Authority, probably you already know this. Number 1, 2014, concerning the alternative dispute resolution bodies in the financial services. So why this is important that I mentioned the legal basis within Indonesian law regime, because because mediation and conciliation is also well known in the international regime as well, probably in United Nations Charter and in another international instruments like in investment and CSI and so on. So I think for those of you concerned with the international law, probably you can tell on what is the difference between the mediation conciliation under international law and mediation conciliation under the national law. We can discuss this. Next, okay, first of all, we're going to discuss the law number 30, 1999 on arbitration and ADR, which under this law, ADR means a mechanism for the resolution of dispute or the difference of opinion through procedures agreed by the parties, which is could be by consultation, negotiation, we've discussed this, or could be mediation or conciliation or expert assessment. So these are we're going to discuss. What is mediation? What is conciliation? The further legal basis stated under this law, Law number 30, 1999, is in Article 6. When previously we have discussed again about this, that the parties who have different opinions or disputes, they shall settle their dispute through ADR, which is they need to direct meeting of the parties. They need to have a direct meeting of both parties within 14 days. Now, this is the case when mediation then becomes applicable if the dispute or the difference of opinion cannot be resolved by the previous means, direct meeting. The dispute or the difference of opinions between parties may be, by the written agreement of the parties, be resolved with the assistance of one or more expert advisors or a mediator, it says. Which is here, it says a mediator. Then, if the parties fail to reach an agreement with the assistance of one mediator, then or probably the mediator does not succeed in bringing the two parties together, then the parties may contact an arbitration institution or an ADR institution to appoint a mediator. So the first one, the parties having a direct meeting and then failed, and then the parties can go to a mediator or probably ask for the assistance from the mediator. And then if it fails again, then the parties can ask to the institution, ADR institution or probably arbitration institution, to appoint a mediator. So in this way, it could be more neutral because the mediator is appointed by a body and by the third party as well. Then after the appointment of the mediator, the mediation process must begin within 7 days. Attend at the resolving of the dispute, shall maintaining strict confidentiality. Okay, this is also important in ADR, especially in mediation, because usually in mediation, the 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 most important principle is the confidentiality, because probably there are some private matter, regardless there is a private things or not, but mediation is basically something private. And they shall reach an agreement in written form which is signed by all the parties, and shall be conducted within 30 days. The written agreement will be final and binding of the parties and should be executed in good faith and must be registered at the district court within 30 days after the signature of the agreement. This is in case the mediation process has been succeeded. And after having a mediation period like 30 days, and then the parties agreed, and then they register the agreement to the district court, and then in this case they shall implement on what are the agreement in the mediation agreement. So that is what happens or what is regulated by the law number 30, 1999. And in this law, it's actually very very general, and it is not that detailed in governing the mediation as well as conciliation. And this is quite different with arbitration, because in this law you probably will see on how the arbitration is being governed very detailed, but the mediation is basically more general, and in some places it's already known, and it's quite common, the mediation, so you can find any references about mediation or conciliation. Then the second one is the Supreme Court Regulation number 1, 2016. Under this law, just regulation law, under this law, the mediation, it says that mediation, it defines mediation as a way of resolving dispute through the negotiation process to obtain an agreement from the parties with the assistance of mediator. Who is mediator in this Supreme Court regulation? Mediator is a judge or other party who has a mediator certificate as a neutral party. They assist the parties in the negotiation process and seeking various possible dispute resolutions without using a forced decision or settlement. And this is so important, as you can see that mediator could be judge or could be just another party other than judge that having a mediator certificate. And this regulation of this Supreme Court regulation applies to both in general court as well as in religious court. So yeah, it's not only in the district court. And then this is, as I mentioned before, that each judge, mediator, parties, and or the legal attorneys are obliged to follow the dispute resolutions procedure through mediation. What does it mean? It means that when you file petition, when you file your claim to the court of a certain dispute, or probably you just become the legal attorney, this is one step that you have to follow and you have to satisfy it. Because first thing, on the first date of the hearing or on the first date of the court or litigation process, the judge will, in case both parties, which is applicant and respondent, are coming before the court, perform before the court, then the judge will declare that the parties should conduct mediation process first, and the judge will, in case the parties have not determined who would be the mediator, then the judge will determine who would be the mediator. And usually the judge will determine one of the judge in the area of the court who has the usually who has the certification of the mediation or certification of mediator, because this is so important, because the role as the judge and the role as the mediator are two different roles, and it's completely different, as it mentions that in mediation it shall not use forced decision or forced settlement. It is quite different, not quite, it is totally different with the judge, because as a judge, the judges shall give forced decision, like punishing the parties, even though it is a civil dispute, and the judge shall give a legal opinion and consideration in regards with the case. And under the Supreme Court regulation, the president of judge appoint a mediator who is not a case examining judge. What does it mean? So usually there are 3 judges in the case. Then the president of judge shall determine a mediator probably from the judge in a certain court who is not becomes the examiner of the case. And then in the case of the judges do not order the parties to take mediation process, and this is important, if there is a legal effort filed by one of the party or probably both, then the court of appeal or the appellate body or the Supreme Court probably could uh, could conduct or order the first level of court to carry out the mediation process. So it come back again to the first level of court to you, hey, you should conduct the mediation process first by an interlocutory decision. It shows on how important the mediation process. it probably a little bit different with the previous Supreme Court regulation on 2008, which was more strict in regards with mediation. Even in the previous Supreme Court regulation in 2008, it clearly stated that in case there is no mediation process conducted by both parties, then the decision of the court or decision of the judge would be null and void. So this is really different. So the next one is the mediation process takes place no later than 30 days from the stipulation of the order of the court. So yeah, in this case, you can find by yourself to open the Supreme Court regulation. Next is the mediation and conciliation within the law on industrial relations. So industrial relations, you can see there are two most important legal basis. The first one is the concerning the manpower or ketenaga kerjaan, the term in bahasa, and then the second one concerning industrial relation dispute settlement. Okay, so let's see the first. It says that first most important thing in concerning the law concerning manpower, that the entrepreneur or the entrepreneur and the worker or the laborer should under obligation to make effort to settle any industrial relation dispute through deliberations aimed at reaching a consensus or win-win solutions. If this deliberation fails to reach a consensus, then the parties shall have the dispute settlement through the procedures for the settlement of industrial relations dispute settlements, which is determined by these regulations. In case the discussion, as referred to the paragraph 2 of this law, result in no agreement to settle the dispute, then the employee from the government agency shall responsible for the labor affairs shall immediately uh, refer the problems to strike to the authorized institute for the settlement of industrial relation dispute. This means that once there is an industrial relations dispute of between the entrepreneur and the labor, or probably the labor union, then they shall settle their problem through a deliberation first. But then if the deliberations fail, then they shall go to uh, conduct the procedures of industrial relations settlement, dispute settlement, which is in this case the parties shall immediately refer the problem to the authorized institute for the settlement of industrial relations. And this is the specific law concerning the dispute settlement within the field of industrial relations. So the previous one is more general law, which governing about the manpower as a general rules. Then in this law number 2, 2004, it concerns more on the dispute settlement itself of the industrial relations. So it says clearly that industrial relations mediation is a settlement of dispute over the rights, conflict of interest, disputes over terminations of the work relationship, and so on, that is interceded by one or more mediators who are neutral. And it says that the definition of conciliations or IR conciliations is the settlement which is concerning the dispute over interest of disagreement over termination of work relationship, disputes between trade unions with one company only, and deliberation interceded by one or more neutral conciliators. I think you can specifically learn about this IR, probably in another subject, or probably you can find the another references about the IR, which is gonna show you that there are so many ADR bodies in Indonesia, including this one. In cases where an attempt settlement through either conciliation or mediator does not result in agreement, then the parties shall file a legal petition to the IR court. The next one is the dispute settlement within the financial services. In FSA, Financial Services Authority has issued a regulation concerning the alternative dispute resolution bodies, which is trying to oblige both the financial services providers or financial services body, as well as the consumer, to conduct ADR first in case of there is a dispute. And in 2016, the OJK, yeah, FSA, issuing an announcement in regards with the list of the ADR bodies, which are, you can see there is a mediation and arbitration body concerning the insurance, and then concerning capital market, and then mediation concerning the pension fund, and then there's also in regards with the banking, and then there's also in regards with the guarantee company, and then the um, finance finance company, and so on. So I think you can find by your own what is the main dispute they usually face, and what are the authority in settling the disputes of the financial services by your own. So now we're moving to what is mediation. Well, previously we have agreed that mediation is actually a settlement, a part of ADR settlement, that involving a third party as a mediator who is neutral, which is probably which could be more than one mediator. And mediation is divided into two kinds of mediations. The first one is the right-based mediation, which occurs where the parties want a neutral third party to provide them an independent assessment of the likely outcome of the case. If there is no settlement at the mediation, the mediator provides an assessment of the legal and equitable rights of the parties, which is in this rights-based mediation, you can read it by your own. It's actually trying to show that this mediation is really to find a neutral settlement, and trying to find the best win-win solution, and the fair one, the fairest, the most justice one mediation. In this kind of rights-based mediation, only a person with some real expertise in the substantive area of the dispute may be chosen. Why? Because, yeah, again, that in this kind of mediation, the mediator shall provide an assessment of the legal and equitable rights of the parties. Just trying to give an assessment, not that really a legal decision. So it's just like an assessment. And then the interest-based mediation, which focusing on the underlying interest, goals, and needs of the parties, rather than on the perceived outcome of the litigation. In this kind of the mediation, the mediator tried to attempt to determine the interest behind the position adopted by the parties. And in this kind of mediation, the mediator trying to encourage the parties to generate options that satisfy those interests and helps them to choose their own best solution. This kind of interest-based mediation probably would be really hard, because usually in this kind of mediation the parties have different interests, and their interests to one another are opposing one another. So probably this might be the hard mediation one. But the next question is whether mediation and conciliation are the same thing, or or both has us or both are similar but different in some you know uh, in some other things. Well, if you see the books that I sent to you in the group last week, you can see that mediation and conciliation is, well, usually people trying to use it interchangeably, like to make both are different. Sorry, to make both mediation and conciliation are the similar, but in some cases, conciliation is different with mediation, which is in the conciliation, it usually denotes the disputing parties which have been reconciled and the relationship has been mended. So that usually happens in conciliation rather than in mediation. In mediation is really clearly the party are trying to find the settlement process by negotiation, deliberation by the assistance of the third party. So these are the mediation agreement. At least it shall consist this points. Appointment of mediator. Who would be the mediator? Oh, sorry. The first one is the title and the parties' identity. Then the mediator, the conflict of interest, what happens in this conflict, in this dispute, and then the cooperation of the parties, the needs of the cooperations, the authority to settle, the conduct of the mediation, confidentiality, privilege, subsequent proceeding, terminations, settlement, exclusion of liability, indemnity, and length of mediation and fees. So those are the some basic things that probably have to be in the mediation. And then the mediation process, the first most important thing is that the mediator shall set the table, which means that the mediation shall know who would be the parties and what is actually becomes the problem. And then the mediation shall state it that his role is as a mediator, which is it is really important because when I mentioned before that under the Supreme Court regulation the judges can appoint one mediator from the judge. um, the judge shall the judge mediator, the judge who are appointed to be mediator, shall state it to the parties that he or she is playing as the mediator, not as the judge. Why? Because this is so different as the role of the judge and the role of the mediator. While the role of mediator is just as the third party who are neutral and trying to assist the mediation, the negotiation, or the deliberation between parties, and trying to provide some solutions, which is the decision is giving the decision to the parties back. So the mediation is really like not that be actively like as being the judge, which can imposing sanction or something. So that is mediation. And it is important for the mediator to discuss his role. Yeah, this is what I mentioned before, which is that he is an impartial neutral with no power to impose an outcome of the parties. Okay, and mediator is not a legal advisor. Okay, he or she is not a legal advisor. He or she, even though he or she is the judge, he knows the law, but he cannot. stated as the legal advice for the parties. He's just probably providing the win-win solution that the parties can take, or the very possible solution. And then mediator sets out the ground rules for the mediation. Yeah, this is also important because somehow when the parties of the mediation are very having a high conflict, um, it's like they have no rules. So in the mediation, probably they can just trying to shouting each other, or probably um, cutting the speech each other and so on. So mediator is important for him to define the rules of mediation. Then there is a term of caucusing, or in Bahasa is also caucus. In US, it is also known as I believe it's private meeting or limited meeting. It's one of the things. So caucusing is actually a deliberate pause in the mediation at the instance of the mediator, with a view to the mediator meeting privately each party or combination of the parties. So um, it could be one party trying to. So usually the mediation is conducted in a certain room, and the room is just only like for a mediator and both parties. So at least it fits for 3 persons. And usually in caucusing, the mediator will just let one of the party to enter, and then trying to tell what is actually the problem, what is your thoughts on this case, and so on. So it is really like a private meeting. And in this caucusing, it provides an opportunity for the mediator to engage in a separate uh, solving. Like, okay, so the mediator trying to know what is A's problem and what is B's problem, and then trying to find and engage their their point of view, because sometimes dispute is just about a point of view. And then the caucus may also be used to assist a party to assess the strength and weakness of a case, or trying to find the best and worst options available to the parties. It also could be used to foster greater trust and confidence in the mediator, thus inviting more fortified response. And then caucusing could also be used as an educational tool to provide explanations, like you're trying to explain that, well, okay, so this mediation is supposed to be like this, and this. So these are caucusing. And then, yeah, caucusing could happens in the beginning of the mediation, or in the amid mediation, or at the end of mediation, which is it has its own purpose. And then the post-mediation process. This is also important, that the most important issue after mediation is the enforcement of the mediated agreement. Once the parties agreed, and the mediation is succeeded, then the parties shall, you know, uh, shall enter into an agreement of the like an award of peace between parties. It proves that, okay, there has been a mediation and both parties are agreed to agreed of certain rules for peace. And then, yeah, there shall be a written report on whether the mediation has succeeded. Like in a litigation process that I mentioned before, the previously before entering into litigation, the judge will appoint the mediator, and in this case, the mediation occurs, the mediation happens. Then the result of the mediation shall be reported by the judge mediator to the president of judge, or the examiner judge. So the judge president, or the president of judge, can determine whether the case would be continued, or because of there has been a peace, so the case shall be dismissed. So it all depends on this mediation first. So those are the things that you can find in these references, and I hope that we can have discussion about this. First, like, what do you think about the difference of mediation and conciliation? Do you think both are these similar things, or probably both are different? And the second, probably you can also define what the mediator or conciliator should do in performing their obligation. I mean, during the mediation or conciliation process, what are their obligation? What are the most important obligation? And then the third, you can probably define the mediation and conciliation under international law, or do you think what I've mentioned are the same or similar to the mediation and conciliation under international law, or you can find any other international instruments regarding this mediation and conciliation? And then the last, please define, or you can issue a statement on how is the benefit of having a mediation or conciliation rather than dispute resolution through the court. So what is the urgency of settling the case from through mediation or conciliation rather than litigation? So those are my explanation for just a slight explanation, and probably just sharing information, because this is just a trigger for us to discuss more. And if you find any mistakes in my explanation or in my um in my speech, you can just let me know, and probably I can revise, or I can give any further um, information for this. So those are the things, and I'm waiting for your responses. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.